If you watched live coverage of the 2025 Waco Annual Charity Open, you may have seen a trademark dispute play out before your very eyes. Hey everyone, it's Chris Clark with DiscGolf.Law. At the recent Waco Annual Charity Open, Isaac Robinson and Kristin Lätt were both seen with tape covering the Latitude 64 curly swoosh logo on their disc golf bags. Why would a major disc golf company ask its sponsored players to tape over the company's logo? There's been speculation that the decision to tape over the logo came from a potential trademark conflict between Latitude 64 and a third party, such as Nike, O'Neill, or Costa del Mar. But is taping over a logo really the way that trademark disputes get resolved? Why wouldn't Latitude 64 be allowed to display its logo on its products? There are currently 3 Latitude 64 trademarks registered with the United States Patent and Trademark Office. In each case, the registered marks are design marks. They're protecting a distinctive logo with particular graphics or stylized wording. None of the 3 are for their curly swoosh logo only. They all contain the curly swoosh logo above or beside the words Latitude 64. During the US trademark application process, the trademark examiners did not think Latitude's curly swoosh was likely to create confusion in the United States marketplace with any existing registered trademarks. Now, to prove trademark infringement, a trademark owner must show that a third party's use of an identical or similar mark is likely to create confusion amongst consumers. Registered trademark owners have a responsibility to monitor third-party use of their trademarks and to detect if any infringement has occurred. If Nike, O'Neill, Costa del Mar, or anyone else perceived Latitude 64's logo to be infringing, it would be standard practice for them to contact Latitude 64, usually through a cease and desist letter, and ask Latitude to stop or at least modify its use of the logo. There's another factor that is potentially at play here: famous marks. One that is widely recognized and it enjoys broader legal protection than ordinary trademarks. To achieve the legal standard of fame, a trademark typically requires a distinct mark, significant advertising investments, and a product or service of lasting value. The Nike swoosh is a textbook example of a famous mark. If Nike perceives that the use of Latitude 64's logo is diluting or tarnishing their brand, even though the visual similarities aren't all that strong, Nike may be able to prevail against Latitude in a trademark infringement lawsuit. And keep in mind, I don't know for sure that Nike or any other famous company is involved in this situation. Almost all trademark disputes end in a settlement. In this case, if a third party objected to Latitude's use of the curly swoosh, it's entirely possible the dispute may have been settled by Latitude agreeing not to use the design by itself, always in conjunction with the words Latitude 64. I've read some people saying that Latitude must always use the logo in conjunction with the words because that's how their trademark registrations appear. But that's not quite accurate. A trademark owner is free to use only part of its registered mark or to use variations on a registered mark so long as those partial uses or variations don't infringe on a third party's rights. But in order to maintain and enjoy the full benefits of trademark registration, the trademark owner must use the mark exactly as it is registered. Let us know what you think. Is Latitude's curly swoosh visually similar enough to any of these other companies' logos as to create confusion in the marketplace? We'd love to hear your thoughts. Please like this video, leave us a comment, subscribe to our channel, and as always, thanks for watching.